Good morning. Good morning to everybody that's attending our seminar remotely. I'm Iqbal Mohammed, and this is our virtual seminar set up by the Sir Philip's Business and Property Group. I'll be joined by Raghav Trivedi and Natalie Kearney, two members of our group and our chambers, to go through this seminar, which starts off with a demonstration of a remote hearing, and then it looks at some practice points that we can draw from the demonstration, covering the preparation and also the hearing itself. Just a little bit about me. I'm a commercial practitioner who's a member of the Business and Property Group, and I am joined by Natalie, who completed her pupillage last year, and she accepts instructions in all areas of the Business and Property Group. And we have Raghav, who is, as of today, still a pupil in Chambers, but I'm told he's recommended for tenancy, so fingers crossed. He will also be a member of the group very shortly. Now, what we're going to do is we are going to do a live demonstration for you, and that will include some deliberate errors. So please bear that in mind, that it's not a reflection of Raghav and of Natalie, but we have tried to make the demonstration useful and practical and cover some of the mistakes or problems that we have encountered as practitioners. I'd also point out to you that in order to make it realistic, but also something that you can relate to or understand, Raghav will set out the facts of the application, which is not normally done in applications like this because the judge will have read the facts from the papers. After the demonstration, we'll move on to Raghav, who will focus on practical points for the audience when it comes to the preparation of a remote hearing, and a remote hearing like this, namely an application of something that doesn't involve witnesses. And then we'll move on to Natalie, that will focus on practical points for the hearing itself. For example, how best to conduct the hearing. I will then finish off with some additional points about the technology and when you might consider instructing counsel as opposed to doing the hearing yourself. And we will open up the floor for questions. So please don't be shy. If you think there are points that we've missed, or if you think there are additional points or questions that you'd like to raise, please do so by chatting to us in the message box. So without further ado, I'm going to start the hearing. Yes, Mr. Trivedi, this is your application, is it?
That's correct, sir. I represent the defendant in his application to set aside judgment, and my learned friend Natalie Kearney represents the claimant. Have you had a chance to read the papers in this matter, sir, or would you benefit from a brief summary of the facts?
No, can you just tell me what the facts are?
Yes, sir. So the defendant runs a successful club on Broad Street, Birmingham, under the trading style Club 24/7. Due to the COVID-19 restrictions, he's had to close his premises and move on to an online platform. The claimant supplied 10 caskets of beer on the 1st of September of this year, with payment due on or around the 8th of September, according to the invoice. Usually the seals on the beers are checked before payment is made, but due to the COVID-19 regulations, as you're aware, sir, the government had ordered the closure of pubs and bars on the 3rd of September. So the defendant and his staff were unable to check the beers. The claimant sent a chaser invoice on the 9th of September of this year, and the defendant responded to the email address set out on that invoice, stating to the claimant that the club was closed, payment would be made when the club reopened, and no one was attending the premises. A similar email was sent out to suppliers on the 15th of September, also informing the suppliers, and including the claimant, that any inquiries should be made to his postal address, 1 Brindley Place, which is also the billing address for the company. On the 25th of October, bailiffs appeared at the defendant's door, at which point it was made absolutely clear to the defendant that a judgment had been entered against him for the invoiced amounts for the beer that had been supplied. And in addition to that, the judgment had been entered on the 21st of October, and swiftly the defendant made his application to set aside judgment soon thereafter on the 27th of October. So those are the facts in brief. You'll be aware of the test for setting aside judgment if you'd like me to move straight on to submissions.
Yes, please. I mean, I understand the test, thank you, Mr. Trivedi, but it seems to me that there was good service here. Why should I be setting aside judgment?
Yes, sir. The point here is service. You're absolutely correct, sir. It's the defendant's position that the sum of the good reason criterion set out in Rule 13.3 is satisfied, and essentially it's the defendant's case that he did not receive notification of the claim form, and that the wrong.
Where does he say that? Sorry.
Sir, so there should be a witness statement and exhibits. Unfortunately, they were provided in two separate emails, but both
Have you
provided.
filed a bundle? I mean, I've got here the claimant's bundle. Are you the claimant?
No, sir. I represent the defendant. Unfortunately, we did not provide a bundle. There was only a handful of papers, so we sent two emails, one with a witness statement and one with the exhibits.
Right. So
If
let
I
me
may,
have a look at that then.
yes, sir.
When
It's
was it
date
sent?
24th of November, sir.
You appreciate that I've received a good 60 emails on the 24th, so let me try and find yours. What time was it?
11:07 is the first email and 11:15 is the second email. I do apologize, sir.
11:07, yes, okay. What am I looking at?
The defendant's witness statement, and there should be a separate email with the exhibits.
I see. Yes, I see. He says here that there was a sign. Where's that then?
Unfortunately, we did not exhibit the sign itself. That's in the claimant's hearing bundle, but hopefully you've seen that, sir.
He says he's exhibited a picture that of his door with a sign on. So where's that being exhibited?
I believe it's page 4 of the claimant's bundle. That's the sign that's referred to. There's a couple of invoices as well.
I see. Yes, I see. Thank you, Mr. Trivedi. Yes, I understand. All further communication should be by email or by post to 1 Brindley Place. I understand. Okay.
Thank you, sir. So essentially, you've heard that there was a couple of emails sent out as exhibited to the defendant's statement, making the claimant aware that any communication should be made to 1 Brindley Place, which is the billing address, and that no one was attending the premises. So it's the first position of the defendant that he simply was not notified of the claim form, and there's a clear reason why, and a good reason why, because of the COVID-19 regulations, he was away from his premises. But that in any event, the billing address has always been 1 Brindley Place, where all communications should be sent. So for the purposes of CPR 6, it's the defendant's position that the wrong address was served. And therefore, to avoid any prejudice to the defendant, judgment should be set aside. Unless you have any further questions at this stage, sir.
Just to clarify, so what your client's saying is, I was trading from the club, but the billing address was always 1 Brindley Place, and as a result of COVID, I had to shut the club down. I put up a sign saying any communications should be to 1 Brindley Place or by email. So they would have seen the sign. And then you also say that he emailed everyone. Is that right?
That's right, sir. But the key point is he simply did not receive notification of the claim form, and it's evidenced why.
But I can't see this email in his witness statement. Where's that?
That's in his exhibit, sir. So that's the separate email that I did mention earlier.
Another email?
Yes. It's dated 24th November, and it's at 11:15.
11:15. Right. Yes. Ah, yes, I see. To all suppliers. I see. Yes. Thank you very much, Mr. Trivedi. Right, Ms. Kearney. Yes, so tell me what you've got to say about this.
I'm grateful, sir. So there's very little between my learned friend and I as to the applicable law. Sir has that. The crux of the matter is essentially service and was it properly served. Now, the claimant's position is that it was properly served, and hopefully, sir, you have to hand my skeleton argument, which was filed last week.
Yes, I do have your skeleton, and I also have your bundle. Thank you very much.
I'm grateful, sir. So I'm talking now, paragraph 4 of my skeleton argument. I've cited there the White Book reference. It's 6.92. And in short, the proper place for service for the claim form was the last known business premises of the defendant, and what was served was the last known business premises of the defendant, being the Broad Street address. Now, my learned friend has made reference indeed to the fact that he was no longer at those premises because of coronavirus. And sir has been taken, in fact, to references in the exhibits in the hearing bundle, which are the sign placed apparently on the Broad Street address doorway, and also references made to an email. Now, in any event, one would expect a competent businessman operating and trading from a certain premises to have redirected his post in circumstances where he knows he's not going to be trading from them, and where he knows he receives communications, including deliveries of beer, for example, as in the instant case, and he failed to do so. And so for the purposes of the test that the court has to be aware of, no good reason has been provided as to why he didn't do so. Furthermore, one would expect him to attend his premises and collect any post that would have been delivered to that address. And he doesn't appear to have done that. And in those circumstances, the judgment shouldn't be set aside. Sir, I refer you again to Mr. Hewitt's witness statement, which hopefully you have in the hearing bundle.
Yes, I've seen that, yes.
I'm grateful. And at page 30 of that witness statement, paragraph 10.
Page 30. I'm sorry, can you tell me what PDF number that is? Not internal page number, what PDF number it is? So I can quickly just get there.
Forgive me, sir, I'm not able to give you the PDF number. If you have on the left-hand side of the PDF document, there should be some bookmarks.
Bookmarks, I'm sorry, I've got a Mac here and I can't seem to find any bookmarks. Never mind, look, you carry on, let me try and get there. And hopefully I'll get there by the time you need me.
I'm grateful, sir. The reference I'm talking about is that Mr. Hewitt sets out the position in relation to the junk inbox email. So the email,
I see.
I'm grateful. The position is simply that their email was received, that's not in dispute, but it was sent, unfortunately, straight into the junk email inbox of the claimant.
Miss Kearney, can I just ask about this? I'm troubled here because they clearly have an existing relationship and the defendant says they emailed the claimant. The claimant, I assume, has had emails in the past from the defendant. And why then would it be this particular email that's been junked? That doesn't really make any sense to me.
Yes, I confess that I'm also not necessarily aware of the IT issue that has arisen. I can perhaps take instructions if you'll bear with me just a moment, sir.
Yes, well, please, if you could, yes.
Thank you, sir. Just a moment. I return, sir. The answer is that there was an IT upgrade shortly before the email was sent. It does it whilst the specifics of the email inbox issue aren't necessarily known. It does appear that perhaps had some root cause for why
hang on a second. There's no mention of an IT upgrade in the statement. When was this IT upgrade specifically?
Forgive me, sir. I didn't get that date when I took instructions. If you bear with me just a moment again, I can check the date for you, sir.
If you must, please.
So it was the week before the email was sent. So it's a very recent IT upgrade, and I apologise it wasn't in the witness statement.
No, it's fine. I understand. So you're saying that it wasn't, strictly speaking, junked. There was an IT problem. Is that right?
Yes, sir. It's not. I can't explain the nature of it without us having perhaps an expert to assess it. But yes, it does appear that caused the email to go into the junk folder.
I see. I see. But it seems to me that there is a very good argument that service should have been at One Brindley Place in any event because that was the billing address.
Sir, my understanding from my instructions in Mr. Hewitt's witness statement is that usually the invoices were addressed to One Brindley Place. That's quite right, but they were handed over at the Broad Street address with the deliveries of the beer. And so while the address was there, it was not the trading premises for the purposes, and service should be at the trading premises, and that was the Broad Street address.
I see. And I've also seen some invoices. The defendant says that a lot of these invoices are made out to One Brindley Place. Where are they again?
That's page 55 of the hearing bundle, sir.
Right. You'll have to bear with me when I get there. And what do you say about these? Are they all addressed to One Brindley Place or not?
They are, yes, they're all to One Brindley Place, but as
That's agreed. Very well. Yes, I see. Yes. Right. That's very helpful, Miss Kearney. Is there anything else?
Unless I may be of any further assistance to you, sir. No, those are my submissions.
Thank you very much. Right. Don't worry, you'll be spared the judgment on a non-existing issue for the non-existing court. Thank you very much to Raghav and to Natalie. Now, before I hand over to Raghav to focus on preparation, I should have just said that before anybody complains into chambers, I'm not Justin Luckman. I am the far more handsome version of him using his account, and that's why I'm called Justin Luckman at the bottom. I'm just getting a lot of abuse now in the chat box saying, how dare you, Justin is far more handsome. Fair enough, Justin, you need to pipe down there. Right, the one thing I will say as the judge, I noticed that when you're being referred to a document, people just assume you've got the document in front of you, apart from the occasions where I couldn't find it and Natalie was telling me where it was, and they just carry on speaking. And it's actually very important that you make sure the judge has the document. In a real hearing, you'd have the visual cue of that, because you'll see the judge flip over the pages and right, he's there now, I can carry on talking. You've got to be much more careful in a remote hearing, because the judge is looking up at the screen pretty much the whole time, and there's no real visual cue that they've got the document in front of them. And it's worth just pausing until they say they've got the document or they've read the document before you proceed. And with that, I'm going to hand it over to Raghav.
Thank you. I'll just share my screen. There we go.
We can see that, Raghav.
Yes, excellent. So we have seen how things can go wrong during a remote hearing, both from a technical and a preparation standpoint. So in terms of preparation for a remote hearing, there are a few pointers to bear in mind. The first is the obvious one, which is the importance of producing, filing, and serving a PDF bundle. Directions may now require this, and a failure to comply with directions, of course, can be met with sanctions. Indeed, I believe Birmingham County Court, for example, requires an agreed core bundle to be filed and served at least 7 days before the hearing, and it's absolutely clear why. It keeps everyone on the same page, it's time-saving, and it avoids judges having to flip around and look for various documents in various different emails, for example, as we have just seen. So it's important to comply with directions as one normally would, even though it is a remote hearing. And even if it's considered guidance at the bottom of the directions order, judges are taking a particular stance and considering them to be more so directions than just simply guidance. Indeed, I had a hearing a few months ago where that was taken into issue, and the judge was prepared to even strike the matter out because the PDF bundle was not, in his mind, an effective PDF bundle with the various hyperlinks, for example. So that moves on to the second point, which is making sure that there's an effective PDF bundle. With remote hearings becoming the norm, the importance of easily accessible and easy to navigate material cannot be underestimated. This means creating an index for your PDF bundle, making sure it's appropriately paginated, and hyperlinked to make sure that the life of all the parties and the judges is made that much easier. I've made a reference to a YouTube video on the page, as you can see, creating using electronic hearing bundles by my colleagues Rob Mundy and Ali Tabari. Very helpful and very effective, and so I would urge you all to have a look at that. It's on the Chamber's YouTube page. Dealing specifically with index and hyperlinks, usually the links that are set out in a PDF bundle, from my experience, provide the link to the start page of a particular section of the PDF bundle. So it might be worth considering a detailed index page to be set out with each document hyperlinked accordingly. That will again make the life of all the parties easier and will make the PDF bundle run that much more smoother. Secondly is the provision of bookmarks. As far as I'm aware, certain computers, for example, MacBooks and their PDF functions don't allow for this. However, there is Adobe Acrobat, and in particular, Acrobat Pro DC, which provides for that facility regardless of whether you're using a MacBook or whether you're using a Windows computer. So that might be worth bearing in mind. But to be on the safe side, it's important that you do not simply assume that the judge is using the same technology as you. It's worth making sure that you set out at the start of the hearing, for example, what limitations the parties are facing and what limitations the judge may be facing from a technical standpoint, so that everyone is on the same page and the judge can be assisted accordingly. But as I say, it's worth investing in the appropriate software. And from my experience, Acrobat Pro DC has been of important use to me. Third is the use of optical character recognition and providing for searchable text. This is a function that's provided for on Adobe Acrobat and worth using, especially when you've scanned across particular documents to create a PDF bundle and you need to search a particular section of a text and you cannot do so. It's important to run the OCR function because that allows you to search that text thereafter. Of great importance is the file size. Sometimes I've had it in the past where a bundle is sent over, but it hasn't reached the court because it's of a size too great. So it's worth compressing the volume of the PDF file or reducing its image quality, which doesn't affect the bundle itself or the ability to read it, but it just makes sure that it's of a size that can be sent, and it avoids the lag when you run through that bundle. As far as I'm aware, there is a function to save a PDF file as a reduced size PDF, or using what's called the PDF optimizer, which I believe is again available on Acrobat Pro DC. Further to that, the importance of using or being able to use cloud functions or cloud links to send across hearing bundles cannot be underestimated either. Certain courts are requiring certain forms such as Dropbox links to be sent across, especially when one is dealing with a great volume of paperwork. I believe Manchester County Court is requiring this at the moment. In terms of planning your emails, now this was a situation that I particularly faced in the scenario we just demonstrated. It's important that you try and plan your emails, and what I mean by this is, instead of sending emails sporadically across a period of time, rather than doing that, to set out your emails so it's, for example, it's 1 of 5 emails, then you're sending the second of 5 emails, and it's done across a period of time, so you can assist the judge chronologically to go through those emails, as opposed to trying to search your email inbox for emails from various dates. Touching base with your opponent before a hearing is also of crucial importance, something that is easy to forget. When you're in court, this is something that's done in normal practice. Speak to your opponent, seeing if there's an opportunity to settle the matter, simply touching base and seeing whether laying your cards on the table, for example. And again, I would urge that this is done before the hearing as well, if you have that information to hand, for example, the contact number for that opponent or their email address. Worth touching base at least half an hour before the hearing. Also of great importance is breaking down your PDF bundle. Certain judges, for example, may require certain document to be provided to them from a large bundle itself. So having the key documents to hand separately in separate PDF format would assist, and it avoids having to send across the whole bundle itself, and again, confusing the judge. And something which I personally faced in a hearing a few weeks ago is the importance of making sure, when in doubt, that you double check that the court has your email address where relevant and the contact number, particularly when you're dealing with BT Meet Me hearings. I've had the situation where a judge has called me, say 10 or 15 minutes into a hearing, to say that the court was searching around for my number, and as a result, the hearing had to start late. So therefore, it's important before a hearing that you double check where there is doubt. For example, where it seems to be that the read receipt hasn't worked, or it seems that the court hasn't responded to your email with the contact number. So those are the key points to bear in mind when preparing for a remote hearing. Please do leave your questions, and I shall move straight on to, Natalie will now move on to considering what happens during a remote hearing.
Before we do, so thank you very much, first of all, Raghav. That was really, really helpful. I endorse everything that Raghav said. I should just say just a couple of things that we pick up on what Raghav mentioned there. Firstly, with regards to PDF optimization, this is a topic that's come up quite often. In fact, if you look at Twitter, you'll see that very often solicitors are complaining about having to meet a particular megabyte limit. And I strongly recommend a piece of software called PDF Exchange Editor, Exchange with an X, not EX, which is a really great program to optimize PDFs down, sometimes even down to 10 or 5% of the starting size of the PDF document. It's a commercial piece of software, but it's not particularly expensive. Also, with regards to what Raghav said about meeting or speaking to your opponent rather in advance of the hearing. So I've done this for all of the hearings that I've had, but nobody's actually done that with me, which leads me to believe that it's not something that's thought about very often. It's really important to meet your opponent or discuss with your opponent whether virtually or by phone, in advance of the hearing, because you then know what it is that's an issue at the hearing. You can't have that kind of discussion in front of the judge, which is what happens now very often. And it's far better to have that discussion. For example, if you agree particular phases of the budget, if you agree particular issues between you, it's much better to touch base and agree on what the topic for the remote hearing will be. And that will allow for the remote hearing to be much more effective and much more efficient. Finally, Raghav also talked about the contact details. You should have the contact details for your actual opponent, so that's the solicitor or the barrister dealing with the hearing, in the remote attendance form. So you should have received that because they're normally copied in to you as well as the court, being sent to the court. So you should be able to get a hold of that. But if you don't receive it, try and make contact with the other side in good time so you can have a conversation with the opponent. Now, with those remarks, I'm going to pass over to Natalie, who will talk about preparation at the hearing.
I'll be covering the hearing itself. So let's bring up my slides for you now. There we are. So hopefully a nice blank screen. So the hearing and what to expect. So first things first, the setup. So I'm going to talk about all the boring practical parts that you have. So think about your camera angles first of all. You don't want to be having a look up your nose, for example, or looking down on you. You want to have the right lighting. I know Iqbal mentioned that he's come across opponents before where they sit in front of a window, so they're backlit, and all that shows then on your screen is a silhouette, which is great if you're a villain in a superhero movie, but not great for a hearing in a court. The judge would probably like to see your face when you're making your submissions. So it's worth having a test run of your setup before you actually get into the hearing. Is the camera angle right? Is your lighting right? Is there an echo in the room that you're in, which could be quite frustrating for those listening to you and also for you trying to follow what's happening. In terms, again, of setup, looking at the screen. So you've seen that sometimes I looked off to the right-hand side when I was giving my submissions. I have a two-screen setup. Some people prefer to have a single screen that they are split with one window for the video where they're looking at the judge and one window with the bundle. Some people prefer to have a paper version of their bundle, so they're able to flick quite easily through the paper version and use the screen solely for looking at the judge and their opponent. So it's entirely what you would prefer to do in your setup and how you want to run the hearing as to what you're comfortable with. The one downside perhaps to having only a paper bundle and using the screen for your video to watch the judge is that if the judge, as in our example, says, well, what PDF page number is that? You don't necessarily have that to hand. So if you are using a paper version of your bundle alongside the electronic version, it's helpful to either have the electronic version open separately so you can compare when needs be to help the judge, or to handwrite on the PDF numbers to your paper bundle so you can assist the court as they use those. If you're using certain platforms for the hearings, some of them allow you to change your name when joining. Now Skype, I think, allows you to have this, when you join you can put in your name, so Natalie Kearney, and it's always helpful if possible to add in brackets counsel for or solicitor for, representative for, and which party you're appearing for. And that just helps the judge and the opponent know who you are. Because we'll all be familiar with multiple parties show up on a hearing, you aren't quite sure, is that the witness, is that the solicitor behind counsel, who are these people? And so that helps ensure that everyone knows who everybody is. So the second part I want to talk about is documents and the white book. In terms of documents, Raghav's covered most of this in his helpful points on preparation, but I'll reiterate it's helpful to have, for example, your pleadings or very important documents in separate PDF files in case the judge says, I can't quite read that in the bundle that I've got, for example, and it happens all the time. Do you have a better copy? And if you have that to hand in a separate PDF document, you can easily, hopefully, and I'll come back to this in a moment, email that across to the judge, and they should be able to access that document more easily without having to delay matters too much. In terms of the white book, you'll have again heard in the example, I had a skeleton argument that Iqbal had to hand, and I could refer to the paragraph so the judge was able to read the wording of the CPR provision I was relying upon. It's helpful for you to bear in mind that the judge may be working from home in their kitchen, for example, and not have their white book to hand. So if you're taking them to parts of the white book, it's helpful to have the wording, either if you've got it on a screen that you can read it out to them from the screen, even better if you've got a skeleton argument that they've got in front of them. It says anyone trying to figure out, well, where is this in the white book? Which version of the white book have you got? Well, mine's the 2019 version, so my page numbers don't match yours. take all of that out of it. If you plan it ahead of time, you should be able to have the wording then to assist. Well, then the biggest issue I think everyone will recognise with remote hearings is in fact taking instructions, because you need to have a system planned out well in advance of the hearing as to how you want to deal with it. And I don't think there is necessarily one perfect approach, but I'll give you some examples of what people have been doing. So first of all, WhatsApp. You can have a secure WhatsApp, you can set it up. The one downside to that is you have to give your phone number to your lay client, if your lay client is the person giving you instructions. You may have a work phone, you may be comfortable with that. You may not if you only have a personal phone, but it's something you can use in the background a lot to get instructions. Alternatively, iMessage, I understand, is quite good. I think Iqbal suggested that was something he sometimes uses. In terms of emails, as I mentioned, judges will happily, I say happily, reluctantly but willingly take emails during hearings if documents are missing, for example. And clients theoretically can give you instructions via email. The downside to emails is it's not instantaneous communication. I know a lot of solicitors firms, for example, have automatic delays on their emails when you send them. Inbox sizes, for example, can cause delays. Some inboxes are set only to update after every 5 minutes or so. So if you're waiting for instructions at a point with urgency, you may not get them very quickly. So email not necessarily the best way to take instructions. And again, there's a good reason to follow Raghav's tips on getting all your paperwork in advance of your remote hearing, so you don't have to wait for the judge to spend 15 minutes refreshing their inbox saying, well, where is this? I'm not very happy with this hearing taking 15 minutes longer than it needs to. So that's something to bear in mind. One other suggestion for taking instructions that I've not tried myself but understand is actually quite good, especially for longer trials, is to have either a separate laptop or a separate device, whether it's a different mobile phone or a tablet, which runs a separate meeting. So let's say you have your Skype for Business remote hearing on one computer, and on the other device you have a separate Zoom meeting with your solicitor or your lay clients, those that are able to give you instructions. Bearing in mind to keep the notifications muted so it's not pinging away in the background. Then you can take instructions quite easily. But do remember that if you're taking instructions, as you saw me do in the example we gave, mute your microphone and turn off your video, because you don't want your opponent or the judge realising what you're saying or what the answers are going to be, and potentially giving away privileged information and having to deal with all the consequences that come with that. And finally, there's my dog Bella, it's the question of interruptions. And some of those you can plan for. So if you have pets, you have children, hopefully you're able to somewhat steer them away during the time of your hearing. But some interruptions, unfortunately, you can't necessarily plan for. Let's say you have a doorbell that goes off, you've got a delivery coming. Theoretically, you can disconnect your doorbell, depends, I suppose, on your setup. What about the postman arriving and setting off the dogs or the kids? What about if you've got work coming outside? What about if you are set up in your home or your office and your neighbour's got scaffolding up and they've got the builders in? They're all things you can't necessarily plan for, but are things to think about as to how you can make sure your space is as quiet as possible, and that your submissions can then be as effective as possible. I'll hand back to Iqbal now. If you've got any questions, do type them into the chat.
Right, thank you so much, Natalie. That was very, very helpful. Now, I just want to pick up on a couple of things that Natalie discussed there. Firstly, she talked about thinking about the environment that you're going to be in when you're addressing the court. You may have picked up the eagle-eyed amongst you. Raghav had a very interesting and busy background, and that was obviously deliberate to contrast that with Natalie's and my own. It's worth having a think about what's behind you when you set up your camera. Of course, Natalie talked about there a brightly lit window or a bright environment, so it creates a silhouette, but also think about the effect of a busy environment and the distraction that would cause the court. It's worth also thinking about the following things in my view. Firstly, platforms. Of course, because of the nature of the webinar, we're running this demonstration through Zoom. You're very unlikely to have a Zoom hearing because of the concerns that HMCTS has with Zoom. So more likely what you will have is Skype for Business or CVP, which is the court's own platform. The sad fact is that unless you have Skype for Business in your firm as a suite, you will not be able to practice in advance of the hearing. But the concept and the way that they run are just the same. The most important thing is not to worry about how the platform works, because you will just have to click a link really and start the hearing. What you really need to focus on is that you're familiar and capable of using all of the equipment that you've got. So for example, if you have a problem with sound, you can't be heard or you can't hear, that you're able to, for example, connect and disconnect and reconnect your microphone, or disconnect and reconnect your headphones. Lots of questions and comments about headphones. Just quickly about the subject of headphones here as well. And this goes to thinking about the equipment that you're using. Think about whether or not it's appropriate to use your big gold Beats headphones that you would normally be using when you're listening to music for a court hearing. Of course, you're not going to win or lose anything based on the quality or the color of your headphones, but it's important in setting the right impression for the court to remember it is still a court hearing, even though you're doing it from home. On the subject of technology and infrastructure, it's very important that you realize that video hearings are quite broadband intensive, so they actually take up a lot of data, going up and going down. If you're downloading things, or people are using Netflix in the background, or using the internet, it's worth thinking about trying to have the whole broadband clear for your use, because what you don't want is to have lags or delays, or indeed the thing going down because people are using up the internet. When it comes to things like the technology that you've got, most firms, from our understanding, are supporting people that are working from home, especially if they're going to be doing hearings. But if you think you need a particular piece of technology, for example, you might need a screen, as Natalie suggested, it's worth thinking about that in advance of any hearing that you're doing, and discussing that with people in your firm to see that you've got the right equipment there. You may even be thinking about fitting things like blinds if you've got very bright windows in the best part of the property that you're living in when it comes to Wi-Fi. So it does require sort of a more broader thinking about the circumstances in which you're going to be attending court from home, and also the kinds of equipment that you've got available to you. It's important that we recognise that, of course, solicitors are more than capable of doing most of the hearings that will be done through the remote video system. But it's worth thinking about also whether you should be using counsel, or whether you could instead use counsel for some hearings. Now, there are a number of reasons behind that. Number one, it might be that actually once you spend the several hours preparing for it and then do the hearing itself, it's more cost effective to use a junior practitioner from a chambers that you're comfortable with. And also, secondly, counsel will have set up that kind of environment that you're trying to create, be it in chambers or in their home, because of their frequency of attending these remote hearings. So you always have the option of using counsel if you think it's going to be too difficult for you on a particular day or a particular hearing. For example, because you've got the children at home, or because you've got builders coming around and you're expecting deliveries. Even at very short notice, it's worth thinking about using counsel instead of doing the hearing yourself, if you can't make sure that the environment is suitable for the remote hearing itself. Finally, it's worth thinking about investment in technology. Now, I say that from a broader firm view, but also the individual's view. If you are going to be doing remote hearings regularly, you do want to, at the very least, invest in things like a proper microphone, a good camera, if your webcam is not suitable. And you also want to be thinking about high-speed internet. I have had opponents who are using, an 8-9 megabyte line, and it's very, very slow, or the picture quality is very poor. So it's certainly worth thinking about the bigger picture of investment if you are going to be doing remote hearings more than infrequently. I know it's tempting to say, well, this is only till March because now there's a vaccine, but actually we don't know how long, or indeed, even if it's temporary, remote hearings will be lasting and will be used by the court. Now, I'm going to stop here. We've had a number of questions and comments, and I'm going to open up the floor to Raghav and Natalie as well. I thought it'd be helpful so you get different perspectives, if you like, from people that are at different levels of court from St. Philip's, to tell Raghav and Natalie what kind of comments we've had, and to get everybody's view on it. Of course, if you think we're wrong, or if you think you've got a different experience of what we're saying, by all means share that with us in the comments box, and we will try to incorporate that and address that. Paul's made the point, and I think a very, very fair point and very true point, that on many occasions he's filed bundles with the judge for them to say they've not received it. And he says that also many judges are indeed on Macs and can't use the hyperlinks. So if we just separate that out into 2 points. Natalie and Raghav, you must have come across that. Solicitors filing a painstakingly prepared bundle, and then you're being told that it's not been received.
Yes. Yeah. So what I would say there is, just as I said in my section, is there's only so much you can do if there are limitations facing the judge. But it's important to know what those limitations are from the outset, so you're there to assist the court as appropriate. As long as you have complied with the directions and what they require, if the judge does face those limitations, you can only assist the judge in that circumstance and do your best to guide the judge. So it's important that you're able to run the PDF as best you can, would be my sort of advice there.
Natalie?
I probably echo the same, to be perfectly honest. We've all been there. Court admin, unfortunately, doesn't always meet what you'd hope it would. A missing bundle is a missing bundle. Some judges let you email it across. Obviously, if it's a small bundle, that's great. If it's a larger bundle, not ideal, because then you might have to send more than one email. You have to do the best you can. Judges are generally sympathetic, as long as you can demonstrate it was filed. And in that respect, if you do instruct counsel for a hearing, if you could copy them in or forward them the email filing the bundle, that can help sometimes with being able to say to judge, yes, it was filed in advance. Yes, we do know it was reached by the court. It's gone missing somewhere at that end, rather than the criticism falling back on the solicitor filing it.
Brilliant. We've then got a question from Ryan. What he says, what he asks rather, he says and he asks. He says that he's very surprised that courts are using Dropbox, and he asks whether or not they direct us to secure providers like egress. Natalie?
So I've had this. It wasn't. I've generally seen orders say, "Can you provide a link to a secure data room or just to a data room?" Dropbox is an example of a data room. I suspect they would obviously prefer you to use a secure one. So if you have egress, that's great. I know some solicitors don't have a specific secure data room that they use, and that's why perhaps Dropbox is something should be looked at. I think there are alternative providers. I think Mimecast is one. But yes, it's not every court. I've had it with Manchester asking for a video, a remote data room to be provided. Some courts will still accept PDFs via email. It seems to be a court by court approach, which is not ideal, I appreciate. But generally there will be something in the directions to tell you what they're expecting.
Raghav?
Yes, just for clarity, so it's not the Dropbox itself, it's just a Dropbox type facility that I was talking about. So it may not be that Dropbox is being used and it is a secure link that is being used. Yeah,
I mean, my experience here is that courts will usually say they will ask for a Dropbox link. What they mean is a cloud link. However, to get to Ryan's point about egress, frankly, the courts are nowhere near that sophisticated in asking you to use particular systems. All they want is a facility for them to download the bundle at their end if they ask for that. They're not particularly bothered about what kind of provider it is. And that's obvious from the fact that they accept email bundles. I mean, email is not a secure system of communication, but they're happy for you to file bundles by email. So I think for certainly the medium term, that is not a real issue that the courts are interested in. If you have a particularly sensitive case and you're worried about that, I think that you will have to make contact with the court and discuss a secure method that you're happy with, that works for you. But do not assume the courts are particularly interested in that topic. From their point of view, and I think in fairness to them, they're not wrong, Dropbox is secure enough and emails are secure enough, even though they're not actually secure systems, certainly the latter. What we've had is from Chloe. Chloe's made a comment saying, you know, if you do get interruptions like the doorbell ringing, what's the best way of dealing with them? Natalie?
Apologise. If you can't mitigate it the best that you can.
Should she leave? I think is the thrust of the question. Should she leave and answer the doorbell, or should she let Amazon come back the next day?
Putting notes on your door is what I tend to do. Thankfully, I don't have a doorbell, so it's not too noisy. But yeah, put a note on your door if you can't avoid it, just in case someone comes calling. Say, please don't knock, please don't shout. Just leave it on the doorstep if needs be. But I think you can only mitigate so far. Don't leave the hearing. If the judge hears something in the background and you can't get away with pretending it was nothing, apologise. You'll have all seen stories on Twitter of people's kids wandering in, for example, to hearing people's cats walking across the screen. All you do is apologise. Generally, judges have been of good humour about it. It happens to everybody.
Raghav, what about you? Are you more committed to your deliveries?
No, not so much if I'm in a hearing. So I would agree with Natalie. Just avoid it if you can. Pretend it's not there. Do apologise, of course, and just carry on. Do the best you can. What I tend to do, especially when you have family in the house, is just make them aware that you're about to enter a hearing and not to disturb you. Or sort of, I try not to use this area, but if I did, especially not to walk past the sort of see-through behind me.
Yes.
That's the worst thing that could happen, is someone peering in. And of course, even directions now require you to be in a quiet room and to make sure no one is sort of listening in. So even if there was a chance of family walking around, judges may take issue to that, because obviously with confidentiality reasons as well, to avoid that happening.
Paul's made a very good comment. He said that he was told of a judge who answered the door and went outside to collect the parcel and close the door behind her. Firstly, I think, frankly, a judge could do what they like, but if you're the advocate, you've got to be very, very strict in what you cannot do, and I would agree with Natalie and Raghav, you should stay where you are. I have loads of deliveries because I have nothing better to do than order rubbish off Amazon and eBay, but what I do is I put up a little note on the door to say, please do not buzz, push the door and leave the parcel inside. And of course, if you're like some of our silks in our group, you can hire a butler. We'll take care of all of that for you. Now, Zoe's asked a question. She said, have you ever been offered, have you ever offered or been offered a test call prior to a hearing to check and access the functionality? I organise regulatory hearings and I found this is most useful. Before I pass this over to Raghav and Natalie, can I just say I was reading a judgment yesterday by Mrs. Justice Stein, and she actually said in the judgment, which involved a litigant person, that this is something that the divisional court does as a matter of course. I didn't quite understand that to mean for everyone. I understood it to mean for litigants in person. So my understanding is that certainly some courts do that with litigants in person, but I've never been offered a test call by anybody in any of the hearings I've done. Raghav, is that different for you?
No, it's the same. I've not been offered a test call prior to the hearing, but I would suspect that it's a good thing for the courts to try and bring in if possible. I would have thought that it's not possible in every situation or every case, given the number of cases that do go on. And if there's a remote hearing, for that to also be sort of a burden on the court, I don't suspect they will do that uniformly. But it would be a good idea.
In contrast, I have. So for telephone hearings, I haven't, but for video hearings, I have. So Birmingham did it for the winding up list semi recently. So the winders list popped in with the usher beforehand, give the details. Everyone's in at the same time, so you have a chance to sort it out there. The roles building tend to do it. When it first started back in March, April sort of time, it seemed to be that it was sent out an invite the night before. You could get in at least half an hour beforehand and have a trial sort of chat through again with the judge's clerk. It seems to be more now moving towards you join it a few minutes early and talk to the clerks at that stage. So yes.
Okay. Sorry, go on, Natalie.
Is it more common for video hearings, I say, than it would be for a telephone hearing, and seems to be certain courts. So again, court by court approach.
Okay, we've got some very helpful comments here, very interesting comments. Ashley's told us that, forgive me Ashley for he or she, I'm not sure, I had the option to do a test call for a winding up list in the roles building, and Natalie's nodding along with that. She says that the same, her experience is the same. Robert's telling us that Coventry has ordered us to do a test teams in advance of the hearing. Paul's still worried about this judge that stopped the hearing to get a parcel. Just on that point, I've not had a test call ever, but I recently had a hearing where I had my twins, who are 15 months, and you can probably tell that from the twin dark circles that I carry around as a badge of honor. I had the twins at home, and I had to move everything that I've got around me to another room. And I did a test call in advance with the solicitor, and it turned out that the audio and the acoustics were completely different to where I'm sitting now. So I do emphasize that although you may not get a test call, there's no reason why you can't do a test call with your solicitor or with your opponent even, or with somebody else in the firm to make sure that the equipment and the audio and the video is working properly. I strongly recommend you do that. Not necessarily for every hearing, but certainly for the first one. And if you change location or change equipment, to take into account anything new. Right now, we've got a couple more questions, so I'll just go through them. Michelle's asking, how would you deal with loss of video? She's making the point here that she had a hearing where the judge froze for about 5 or 10 minutes, and everybody just carried on hoping that he was still there. And it turned out that he wasn't still there, and they had to redial into the hearing. So she's wondering whether or not it's the right approach to allow for the freeze and just carry on, assuming it's okay or hoping that it's okay, or should you do something else? What do you think about that, Natalie?
Depends somewhat to the extent they've frozen. I think you can carry on if they've paused for sort of 2 seconds, and if you think after about 10 seconds they've still not moved and you haven't heard anything from them, you might want to say, "Forgive me, are you still there, sir?" Just to check that they are still able to hear you. Because if the video's gone, the sound might still be there, they'll answer you. And then you've clarified, rather than keep talking for 5 or 10 minutes and then find you have to start again. And you've made your best point once already, and now your opponent's prepared for it the second time around. So best to check.
Raghav, what would you do?
No, I agree with Natalie completely. It's best to check. The worst thing that can happen is you're making your submissions and the judge has not heard any of it, and you've assumed the judge has, and the judge doesn't take issue either, and there's a miscommunication between the two of you, and in the judgment the submission that you made isn't mentioned, for example. That's sort of a nightmare situation to happen. So it's best to clarify sort of immediately if you feel that the judge has frozen, and then continue. I don't think any judge will take exception to that, the way things are running.
Okay, great. I've had a new question from Lauren, a really interesting one actually. Lauren asks, if the hearing is in person and counsel has been instructed to attend, how can the instructing solicitor attend remotely? Have either of you had a situation like that?
Sort of. So if you have a hybrid hearing, you would expect directions to be given for how those not attending in person can attend remotely. So you'd hope you'd have a hearing beforehand. I've had it where I've set up a directions hearing. So for your PTR that would usually take place, the judge might schedule a week before the actual trial, for example, if you've got a long trial, another hearing to look at who's attending in person, what platform can be used to stream it from the courtroom, whether there needs to be a laptop, is it going to look at the judge, is it going to look at the witness? In terms of if that's not a hybrid hearing, well, it's just a normal hearing, unfortunately, unless you have permission to attend remotely and everything's in person. It would be the normal way of instructing counsel. Counsel goes along and the solicitor isn't there. If you want specifically to attend remotely, you would then you need directions from the court. So you need to get in contact with the court and say, well, we want to attend remotely. Is the judge happy for it to be broadcast? I think there's Iqbal might know the name of the case. Actually, this happened in a London Rolls hearing where the solicitors were essentially live streaming remotely, shared the link with their clients, and the clients were watching it, and the judge wasn't aware they were actually on the line. And there was a great deal of difficulty then for the solicitor who had broadcast it without permission. So there has to be some court authority for broadcasting it remotely to that solicitor. So you want directions, ideally.
If I could just chip in there, I mean, that particular case is a very good example of why you should not be sending out links to the hearing, even to your clients' different departments. So be very careful with who you share the link for a remote hearing. But to answer the question directly about the scenario that the questioner is asking, what I would do is, for example, if the solicitor is isolating, or if the solicitor is not comfortable attending in person, if you can't deal with it in advance, on the day of the hearing, ask counsel to, for example, turn on their laptop and request that the solicitor can listen in or watch the hearing. But I would ask the court very clearly for that, and you never know, the court may be happy to oblige. I mean, it's a difficult circumstance, the coronavirus and pandemic, and courts are very, very helpful and constructive about things like that. I can't imagine that's going to be a difficulty if you explain that your solicitor can't attend for whatever reason and would like to listen in or see the hearing. Just following up on that, Paul's asked a question saying, what if the hearing is remote, but you know the judge is sitting in court? Can you attend in person? Natalie's shaking her head. I was going to say, no, you can't, or Raghav is also shaking his head. Paul's asking because he wants to deal with plans and boundaries. and dealing with that remotely is a nightmare. And I totally understand that, Paul, totally agree with that. But what you would want to do is in advance agree that sort of thing with the court. So you probably want a direction to the effect that there will be a remote hearing, but X can happen in person. Now, the reason I say that is because it's a funny sort of system at the moment. Some judges are in court at every hearing, and some clearly are not. So it's not a good assumption to make that they're in court and rolling up to Coventry County Court or wherever it is, and they're looking for the judge. But equally, they may be in court, but not expecting you to be there, or not prepared for you to be there. So things like that, I totally understand. It makes complete sense. But what you want to do is you want to agree that sort of thing with the court.
If I can add
sorry,
that,
go on, Natalie.
Okay. Just by way of practical example, I know that I've seen it happen with the winders list. Everyone was remotely attending, but some people turned up on the day, as you would normally expect with a winding up petition. And they were made to carry out their submissions on their phone from the reception of the court building, while the security staff tried to herd them out of the building. So if you're there, they were just going to say, well, security have told me they're waiting, so I'll let them in. They will not let you in the building into the courtroom.
Okay. Well, we've got a little hive of activity in terms of questions and comments. Let me just deal with what was originally the last question. What I've been asked here is, what's the best way to practice for a remote hearing? So I'm assuming this is more about advocacy and not the technology. What would you suggest? Can I ask Raghav? Raghav, what do you think about that?
So what I personally did was I would use, for example, Zoom or something, just and keep the camera on and practice to myself, maybe record it and watch yourself back. That might be a good way of practicing, I would have thought. And just on a more general note, practicing the various softwares that are available to use, and making sure you're able to use them all the various functions. I would have thought that's the best way to go about it in terms of practicing.
Good. I'll say that we are, contrary to popular belief, we actually did practice the demonstration, and the biggest thing that we picked out was the speed of speech, because we were all speaking far too fast for video, although it would be okay in person. And the real focus of our practice was slowing down the speech for a video hearing. So it's really important that you practice that. Whether you do that in front of a mirror or do it with the webcam on, make sure you really slow it down so the judge can pick up on everything that you're saying. Right, a final question. I've got another question unless there are any more. This one is from an anonymous attendee. Welcome, anonymous attendee. How are the courts approaching remote hearings where oral evidence is required, be evidence of fact or expert evidence? Now, I've got something to say about that, but what I'm going to do is I'm going to let Natalie speak first, because I know that she's had some experience with this. Natalie?
Yeah, so I've done a couple of fast tracks remotely and a couple of small claims as well, actually, now via video hearings. If you've got evidence that needs to be given orally, it's always better to have a video hearing rather than a telephone hearing, because then you can read the person that's giving the evidence. There are a lot of practical issues to be aware of. We had a chat about this yesterday. Normally you swear in your witnesses if you're not in a small claim. You wouldn't necessarily have the Holy Book to hand, so the judge might simply make them affirm. Asking cross-examination questions, it's difficult to cross-examine on video link. It's more tiring. You can't read the same body language, but it's doable. So it depends on the type of case you've got as to whether you think it's going to be appropriate. And the courts are alive to the fact that, for example, if you're talking about dishonesty, then you're going to want to deal with it in person. In terms of practicalities, everyone then all your witnesses need to have the same bundle. Is it electronic or is it paper? Do they all have the same pagination? Are you going to have 3 witnesses in the same room as each other? Is that going to raise issues if they're not giving each other answers and looking at the same documents? It is more complicated, but it's doable. It's definitely doable. We had a 4-witness fast track that went absolutely fine. So again, it just depends on the type of case and how willing the court are to provide directions to make it happen.
Very helpful. If I may say so, that this is where ideally you do want to really seriously think about using counsel, because chambers will have very large conference rooms and will have facilities set up for the use of witnesses. So for example, for your witness, it's ideal that you have the witness and counsel in a room together, obviously socially distancing. But so we are able to control the technology and control the video and to control things like the internet connection for the witness. So we're not relying upon them sitting in a car park or God knows wherever they're sitting, relying on them not to have interruptions, relying on them having the right environment to give evidence. So it's very important that you use, in my personal opinion, you use chambers or use the firm's resources to ensure that the witness is best placed to give their evidence to the court, and don't just leave the witness themselves to log into the hearing and then to give evidence from wherever they are. That is really risky. And remember, just like you're dealing with when you're dealing with live witnesses, the skill of lawyers is to allow for the best presentation of evidence to the court, and don't think that, oh, because it's a remote hearing, that doesn't matter. It still matters. It matters even more, because the impact of not having the right technology, not having the right camera, informality can actually be very damaging when it comes to witness evidence. Now, Raghav, is there anything that you want to say about that before we finish?
No, I think that's well covered, and I think I agree with you both in terms of how to approach witness evidence more generally, whether that's expert evidence or otherwise. It's the presentation is absolutely key when you're dealing with remote hearings. What I could add actually is when you're in front of a camera, you're much more exposed. So therefore, your presentation, the way in which the witnesses present themselves, the way in which you make your submissions is that much more important, because the judge can see every sort of body language, movement that you make, the way in which you set out your submissions, the pace of your submissions. It all comes to light in front of a camera.
Brilliant. Right, so now that is 10:30. We've spent an hour. We had not expected so many questions and comments, so I'm sorry that if for some participants it's gone on a bit longer than it should have. But we're very grateful for all of you attending the seminar today, and we're very grateful for all of your questions and comments. We are always available in chambers to handle any questions or inquiries that you've got, whether it's about this seminar, preparing bundles, or if you're dealing with your own first hearing. Do feel free to pick up the phone and speak to Raghav or Natalie or myself. We are more than happy to assist in any way that we can. Thank you so much for attending this BPC seminar, and we look forward to seeing you at our next remote seminar. Thank you.
Thank you.
Thank you.